This is the crazy and tragic story of Aretha Franklin's passing and her lack of a proper estate plan. Let's take a step back. Aretha Franklin, extraordinary artist, passed away in 2018 after a long cancer battle. After she first passed away, it was believed that there was no will and no estate plan in place. But later, not one, but two separate handwritten wills were found. Her eldest son, Clarence, has special needs. Her estate was worth around $6 million. At the time of her passing, her niece, Sabrina Owens, was unanimously selected to be the executor of her estate to oversee that process. And Miss Owens found not one, but two different handwritten wills. One was written in 2010 and another was found in a couch cushion dated 2014. The 2010 version was apparently notarized while the 2014 version was not. And the different wills had different provisions. One will favored two of her sons, another will favored a different son, and none of them had special needs provisions. And what happened? Well, there was a court battle over which one was valid. Now, first off, these were holographic wills. They mean they were handwritten. Miss Franklin didn't use an attorney. Her attorney apparently told her to set up an estate plan. She never did it, but she wrote these by hand. Now, handwritten wills can be valid in some states, and where she passed away in Michigan, a holographic will, handwritten, is valid. In some states, it wouldn't have been valid, but her family was lucky this way. Two of her sons were favored in one will, another son was favored in the other will. And there was a battle. It actually went to court and had to go in front of a jury. And eventually, the jury determined that the 2014 will was valid and thus superseded the 2010 will. So what can we learn from this? Well, I think one lesson, I wouldn't take this, is a holographic handwritten will is valid in some states, but not all states. You should never rely on just that. Much more importantly, Miss Franklin should have set up a living trust, and she should have done it with an attorney. If she'd done it with an attorney would have been able to oversee the process with her, defend it later if there were challenges, verify that it was indeed her wishes, and it would have directed assets where she wanted. Properly set up trust would have kept her assets out of the courts. One of the reasons apparently that she didn't set up an estate plan with an attorney was to stay private. And ironically, by not working with an attorney before and keeping things so close to the vest, all of her family's affairs spilled out into the public because this was all done in court. So if you set up your own living trust and properly fund it, transferring your non-retirement accounts into it, you can be sure that your wishes are followed and that your estate and your issues stay out of the courts, saving time, money, and complications. Set up the living trust, make sure it's proper, do it with an attorney so the attorney can help you through the process, make sure it's done right, and defend it for you and for your family if there's ever an issue later. So let's all learn from this case and avoid our affairs being spilled out in the court and probate.